Sikhakhane.
Thank you, Chair. Chair, so much has crystallized in this case, and so I'm not going to waste time about traversing what this case is about and all the elements. But I want to start with this, because there's a lot of mischaracterization that can happen in a case like this. And I'm going to start with what it's not about. And then I'll get to what it is about. This case is not about, and has never been about, the following: whether the complainant endured inappropriate comments and gestures regarding her physical appearance. Indeed, neither in a complaint nor in this tribunal did the complainant make comment about those claims. The second point is that this case is not about whether the conduct of the Judge President contravened or breached Article 5.1 of the Judicial Code of Conduct, which says as follows: a judge must always, and not only in the discharge of official duties, act honorably and in any manner befitting judicial office. It's not the case that was in the notice for him to meet. Second, that all activities of a judge must be compatible with the status of a judicial officer. I'm not saying these are unimportant. I'm saying the case that he came to meet was not this one. And what was the case to meet? And these have no competent verdicts. What I'm about to read, which is the case that was presented for him to meet. And it's found in Form 2, which is the notice in terms of Rule 4 of the Rules Regulating Procedures. And the note that notified the respondent about the case that he had come to meet said, and I quote, "It is alleged that the facts set out in Annex A to this notice constitute a complaint of gross misconduct against you," close quote. And Annex A made reference to the complaint by the complainant, Ms. Mbenenge, which is dated 12 January 2023, I'm sorry. And the notice further notified the respondent that, quote, "A concise summary of the evidence and any other information which substantiates the complaint against you is set out in Annex B." And what does Annex B state? It states as follows. The heading there is concise summary of evidence. "It is alleged that between June 2021 and November 2022, you sexually harassed the complainant, Ms. Andiswa Mengo, by A, sending her on WhatsApp messaging service unwelcomed, unwanted messages of a sexual nature, as well as crude pictures. And lastly, B, behaving indecently towards her in your office at the High Court in Umtata," close quote. The contents of Annex B, of course, mirror the JCC's summation of Ms. Mengo's complaint. And at paragraph 1, the JCC summarized the case made by Ms. Mbenenge in her complaint in the following terms. And I quote, "She, Ms. Mbenenge, alleged that between June 2021 and November 2022, the Judge President sexually harassed her by A, sending her on WhatsApp messaging service unwelcome, unwanted messages of a sexual nature and crude pictures, B, behaving indecently towards her in his office." Similarly, the similarity of the words in the JCC's summation and the terms of Annex B is stuck for a reason, of course. This is hardly surprising. After a thorough examination of the parties' assertions that Ms. Mbenge's complaint and the respondent's response, the JCC identified the issues which it was called upon to determine in the following way, quote, "The inquiry at this stage is whether the Judge President's conduct prima facie constitutes sexual harassment." This is at paragraph 21 of this. And it went further to make itself clearer at paragraph 24. The JCC then identified the issue before it as follows, quote, "As a prelude to considering the complaint before us, it is common cause that the Judge President made sexual advances to Ms. A.M. I think it's Ms. Mbenenge. The question is whether those were unwanted, and if so, whether the JP knew or ought to reasonably have known that they were unwanted." Of course, the narrow campus of the inquiry is much clearer and perspicuous by the ratio of the decision to recommend the referral to this tribunal, which was made at paragraph 27 by the JCC. It says, "The contours of sexual harassment are complex, and in this case, they would be best resolved in an investigation where the parties' versions would be tested through cross-examination and possibly expert evidence. For example, this committee is not equipped to determine whether certain pictures were downloaded from the internet, as alleged by the President or sent from the Judge President as alleged by Ms. A.M. The most appropriate conclusion is to refer all those aspects, including the contents of Acting Deputy Judge President's affidavit, for further investigation. Now, this, of course, this summation accords with what we would call a liberal reading of Ms. Mengo's complaint as set out in Annex A. Therefore, this is the case that is to be determined, and this is the case that the respondent was to meet, so that it's not mischaracterized. And of course, my parting shot in this is that while there are issues that are disputed, and there are facts that are disputed, it will be revealed through his own testimony, the conversations that he had. And those will become clearer because they are uncontested. As he testifies, he will demonstrate to the tribunal which things in the entire accusations did not happen, which pictures are alleged to have been sent by him, but he didn't. The rest of the evidence is factual and has been led, and experts have appeared before this tribunal. And to make this entire case and to give the facts that support his version of events, the following witnesses will be called. The first one, and I would like to give the tribunal the entire list once and for all. And in fact, I'm giving it in the order in which they will come. The first one will be Mrs. Ntlengai. The second one will be Ms. Unathi Sogoni. The third one will be Dr. Mello. And the last one will be the Judge President himself, the respondent. And at this point, Chair, I would like to hand over to Mr. Madonsela, who will deal with the first three witnesses that I've mentioned, and I'll hand over to him as we start our evidence. Thank you, Chair.